Law Moot Court Board, I'd like to thank you all for joining us today. Each year, the board selects a real-world legal issue that is both topical and academically challenging. The board selects cases that have worked through the circuit courts, often resulting in a circuit split, and in some cases, resulting in a petition for writ of certiorari to the Supreme Court. 3 years ago, the board selected government wiretapping. 2 years ago, they selected voter ID laws. Last year, the board selected the death penalty in California. And this year, we have selected restrictions on doctors asking patients about firearm ownership in the state of Florida. For many second and third year students, Moot Court is the first time they are applying doctrinal learning to advocate for clients against a complex record, as well as maintaining persuasive arguments in the face of some pretty tough questions. Today, you will see the product of months of research, writing, and oral advocacy. Now, please welcome our new dean, professor of law, and role model, Song Richardson.
I'd like to welcome everyone to our 2018 Experian Jones Day Moot Court competition. I am incredibly excited to hear our students argue. And as the president, where did she go? The president of our Moot Court board, Emma McBurney, stated, they worked incredibly hard for today. And the slate of student competitors was unbelievable. And so you will see the best arguments today. Before I introduce our judges, I just want to thank all of the people who made today's event possible. So first, I'd like to thank very much Experian and Jones Day for their generous sponsorship over the years of our Moot Court competition. Next, I'd like to thank the president, Emma McBurney, all of the students on the Moot Court board, and their faculty advisors, who I don't see in the room right now because they're upstairs with the judges, and that's Michael Robinson-Dorn and Rachel Kruskery-Roberts. Finally, it does take a village to organize an event like this, and we're very lucky to have an incredible team of assistant deans, senior administrators, and staff. So in alphabetical order, I'd like to thank all of them too. Joe Dunn, Jillian Henry, Jenna Jones, Cynthia Ryan, Liz Schrader, and Colleen Terracani. So can we give a hand for everyone who was involved in making this event possible? Now it's my great pleasure to introduce the three judges who will be judging the competition today, and I'll introduce them in alphabetical order. So first, there's Justice Richard Aronson. He was appointed to the California Court of Appeals in 2001. Prior to that, Justice Aronson was a judge on the California Superior Court. He was a Superior Court commissioner, an Orange County public defender, and a deputy DA for San Bernardino County. That's an unusual combination. Justice Aronson currently teaches as an adjunct professor here at UCI Law. And Justice Aronson earned his BA and his JD from the University of San Diego and his Master's of Law degree from the University of Virginia. Next is Judge Mark Bennett. Judge Bennett is in his 23rd year as a U.S. District Court judge for the Northern District of Iowa. Prior to his appointment on that bench, he was a civil rights lawyer and a criminal defense lawyer, and then he was appointed to serve as a U.S. magistrate judge in the Southern District of Iowa. Judge Bennett argued his first case in the U.S. Supreme Court less than 4 years out of law school. He's also authored 24 law reviews. Judge Bennett is often introduced as the lawyer who sued the president, the Pope, and the 9 justices of the Iowa Supreme Court in a 30-day period, winning all 3 cases. Finally is Judge Josephine Staton, who is a U.S. District Court judge in the Central District of California, located in Santa Ana. She was appointed to this position in 2010. Prior to that, she served 8 years on the Orange County Superior Court bench, and she earned her JD from Harvard and then clerked for Judge Gibson on the U.S. Court of Appeals for the 8th Circuit. After that, she worked at Morrison and Foerster until being appointed to the bench. In 2001, she was honored as the Orange County Trial Lawyers Association Employment Trial Lawyer of the Year. So I look forward to this argument. I hope all of you do too, and let the competition begin.
All rise. Oyez, oyez, oyez. The court is now in session. The Honorable Justice Aronson, Justice Staton, and Justice Bennett presiding.
Good afternoon. You can have a seat. All right, we're going to hear this afternoon the case of the governor of Florida versus Woolshaliger. I hope I pronounced that correctly. So, your appearances, please. Okay, and we hear from the petitioner, so you may proceed.
Mr. Chief Justice, may it please the court. I would like to reserve 4 minutes for rebuttal. In 2011, the Florida state government enacted the Firearm Owners Privacy Act after learning of several troubling incidents between doctors and patients concerning the patient's firearm ownership.
Counsel, how did Judge Cook at the district court in the preliminary injunction ruling distinguish the Casey decision in footnote 7 of her opinion?
Your Honor, in that decision, the court distinguished the Casey opinion on the basis that in Casey, first of all, it was a plurality, and second of all, it has to do with the compulsion of speech, and in this case, it's the restriction of speech.
How is that a difference that makes a difference in terms of our level of scrutiny?
First of all, Your Honor, it makes a difference because in this case, the restriction on speech is merely the restriction on irrelevant, unnecessary, and discriminatory speech. And in that case, it had to do with actual medical advice. In this case, the FOPA provisions do not concern the ability of the doctor to give gun safety advice whatsoever.
So what standard are you saying we should apply here?
Your Honor, for the discrimination provision, the appropriate level of scrutiny is rational basis because it is not a restriction on speech. It merely has an incidental effect on speech. However, if the court is considering all four together, then the restrictions on speech would constitute a heightened scrutiny standard.
It seems more than an incidental restriction on speech. It's prohibiting an entire subject.
Your Honor, under United States v. O'Brien, the court held that it can look at the purpose of or the targeted behavior that Congress intended to prohibit. And in this case, the targeted behavior is not simply the communication of discriminatory acts. It is the discriminatory acts themselves. For example, there's an incident in the record where the doctor told a patient that she had 30 days to find a new doctor. In that case, the prohibited activity would not simply be the notification, it would be the actual termination of the doctor-patient relationship.
Leaving aside the anti-discrimination provision, why wouldn't we apply strict scrutiny to the rest of this after Reed?
Your Honor, in Reed, the court, nowhere in Reed did the court say that it was overruling decades of precedent that applied heightened scrutiny or intermediate scrutiny to different categories of speech. In fact, under Justice Breyer's concurrence, Justice Breyer noted that the court could not have been intended to impose an automatic trigger for strict scrutiny, because if the court did that, then otherwise constitutional speech would be rendered unconstitutional, or the court would be faced with the challenge of watering down the strict scrutiny analysis.
So under intermediate scrutiny or heightened scrutiny, you would acknowledge that it has to directly advance a substantial government interest, correct?
Yes, Your Honor.
And that it has to, there has to be a fit between the legislature's ends and the means that are chosen, correct?
Correct, Your Honor.
How can you ever have that fit when all you have is anecdotal evidence?
Your
5
Honor-
instances of anecdotal evidence, or 6?
Your Honor, that's a good question. In Nixon v. Shrink Missouri government, this court noted that the government's burden of proof varies up or down with the novelty and the plausibility of the justifications offered. And in this case, the justifications offered are not novel. They go back centuries for the Second Amendment, patient privacy, and ensuring high professional standards.
Well, isn't it novel to essentially say that you're going to protect the Second Amendment right to bear arms by essentially preventing any criticism or comment on that right? I mean, these are private actors, correct? The doctors are.
Yes, Your Honor.
So there's nothing that a doctor can do that would amount to prohibiting or preventing someone from actually exercising the right to own a gun.
Your Honor, I believe that your question goes to how the record supports the substantial governmental interest or even a compelling governmental interest. And in this case, it does so by the fact that the prohibited conduct or speech actually chills the Second Amendment right. And in Burson v. Freeman, this court held that a chilled right is enough to support a substantial or compelling governmental interest.
But counsel, in this case, there are 6 incidents that are referred to, but in all 6 lower court opinions, there's no indication that the state actually put on any evidence that any of these 6 incidents actually occurred, because it's all second, third, and fourth level hearsay. So how do we know that any of the incidents actually occurred?
Your Honor, there is some reporting by local newspapers as well as reports in the legislative history. However, we need not delve too deeply into this because, again, it depends on the novelty and the plausibility of the government's justifications. And just to add to that, considering the sensitivity of the information that is at issue here, it's medical records, and these are considered sacrosanct by the Supreme Court's jurisprudence. And so it would contradict the government's intended purpose to protect patient privacy to be too intrusive into the patient's stories.
I'd like to ask you a question about how the statute operates. The statute prohibits the doctor from asking about gun ownership unless relevant to a patient's medical care or safety. Considering the statistics of accidental gun deaths and injuries involving children, isn't it always relevant to ask a patient about gun safety?
No, Your Honor, and I believe that your question goes towards the statute's vagueness. And under the record keeping and the inquiry provisions, you're right to point out that relevance is the conditioning factor. And if we look at the plain meaning of relevance, it's the Oxford Dictionary actually defines it as pertaining to the matter at hand. And the matter at hand is the patient that the doctor is dealing with right then and right there. So in order to for the doctor to make a determination of what is relevant or irrelevant, he would have to look at the patient at hand. And in doing so, he can look at several red flags that the AMA itself has identified. And those might be patients with younger children, patients with a history of domestic violence, or patients that exhibit suicidal thoughts.
Well, I understand that the doctors have to have a good faith basis for making the inquiry, correct?
Yes, Your Honor.
So a doctor that had a standard procedure of asking all parents of toddlers or children whether they have guns in the house would not be asking in good faith about that, would he? They wouldn't have any personal information about the particular patient and their relationship to guns. It would just be an across-the-board question asked to every patient that comes in who has children. That would be impermissible, wouldn't it, under this statute?
No, Your Honor. If the doctor in good faith believes that every parent has the duty to safely secure their firearms, and I believe that this is advised by the AMA, that would be enough to satisfy the statute, as long as it's a good faith belief.
Counsel, what's the privacy interest that the state of Florida alleges is advanced?
Your Honor, the privacy interest is in protecting patients from unnecessary or irrelevant questioning and harassment.
So
as well.
the privacy interest, it's interesting because the doctors can't disclose the medical records without the patient's permission.
Correct, Your Honor. However, there are many types of privacy interests. They may include securing data, they may include asking intrusive questions, they may include asking intrusive questions 3, 4, 5 times.
So, counsel, are you saying there's a privacy interest in the Second Amendment right to own a firearm?
Yes, Your Honor.
Well, let me ask you this. In order to buy a firearm from a federal licensed dealer, which is where most firearms are purchased, the Alcohol, Tobacco, Firearms, and Explosives has a form called the 4473. It has 37 questions with subparts equaling about 60 questions involving mental health, criminal history, marital disputes, and the like. If a patient has to disclose that when they buy a firearm, how can there possibly be a privacy interest in disclosing it to a doctor?
Your Honor, there is a privacy interest beyond that initial filing because the state of Florida does not disclose that type of information. There are many mechanisms that the state of Florida uses to secure that data. And if the patient does not choose to share that information beyond the initial licensing of obtaining a firearm, then the patient should not have to do so.
Is anyone challenging the provision in this law that allows patients to simply refuse to answer the question if it's asked?
No, Your Honor.
So if they want to protect their privacy rights, they can say, I choose not to answer.
Your Honor, that is a good point. However, we have to keep in mind that within the doctor-patient relationship, there's an imbalance of power between the doctor and the patient. It may be that the patient has the right to refuse to answer these questions. However, if the other provisions are not upheld, then it's still the doctor's right to terminate the patient on the basis of that refusal or to discriminate against that patient or to keep asking these questions.
But these prohibitions only apply, as I understand it, from looking at the statute, during the examination, right?
Yes, Your Honor, one of them does.
So if the doctor were to talk to the patient before the examination, the doctor would there be nothing to prevent the doctor from asking the patient about that or disseminating information about gun ownership or having the patient watch a video on the dangers of gun ownership?
Your
Correct?
Honor, the only provision that restricts the scope of the location or the actual treatment would be the harassment provision, and that is during the course of the examination. That's part of the language of that provision. However, the inquiry and record-keeping provisions extend beyond that. They extend to the, however far the scope is of the doctor-patient relationship.
So as I understand it, then the doctor can harass the patient before the examination and after the examination, but not during the examination.
Yes, Your Honor, but that would mean that the doctor's acting in his own personal capacity outside of the fiduciary relationship, and I believe that that relationship carries beyond simply the 4 walls of the examination room.
Since we're on the subject of harassment, isn't the dictionary definition of harassment to annoy persistently? Isn't that what the lower court said when they looked at Merriam-Webster?
Yes, Your Honor. However, the Oxford Dictionary also defines it as to wear out or to tire out. And in this case, while the respondent may have an issue...
Which definition applies here?
Your Honor, it would depend on the court applying it, the medical board applying it. However, turning to the anti-harassment provision, it only falls on whether or not the doctor believes it to be necessary. And while the respondent may believe that this is troublesome, it in fact allows the doctor the deference or the ability to persistently care and not have his or her speech chilled if the patient exhibits a need for that type of care.
Counsel, ready for a hypothetical?
Yes, Your Honor.
Okay. A group of doctors are at the Orange County monthly medical meeting, and a group of plastic surgeons, of which there are many, who are Trump supporters, decide that they're going to ask their patients who they voted for in the 2016 election, and then they're going to counsel the patients to support Republican candidates in the 2018 election. And if they don't agree to provide the information, they're not going to provide the plastic surgery procedure. So the state gets involved, and they pass a law that says the doctors cannot discuss political affiliation or politics with their patients. Would that be constitutional?
Your Honor, if we're applying the strict scrutiny standard, it would not, because it would not represent a compelling governmental interest.
Isn't there a compelling governmental interest in the privacy of how people vote?
No, Your Honor, because the court in California Democratic Party v. Jones actually compared the two, the party affiliation and medical information, and it held that the only one that was considered sacrosanct is medical information. And being that the party affiliation does not pertain to the patient's well-being or health or care, it would not withstand that type of scrutiny. Moving back to the preliminary issue at hand under the First Amendment analysis, we must consider whether or not the restrictions apply to conduct or speech. And again, just noting the discrimination provision applies to conduct because it merely has an incidental effect. And we know this because the government intended to regulate conduct rather than speech. And moving to the next issue, assuming that all four provisions are speech, we can look at the commercial speech doctrine as a guiding principle because, as you are all aware, the professional speech doctrine has never been ruled on in this court in a majority opinion. And there are two ways that this court can find guidance from the commercial speech doctrine. The first is in the court's opinion in Central Hudson, it held that it must recognize the common sense distinction between speech made in a traditionally regulated context and speech, other types of speech. And that same logic holds true here. In this case, the field that the speech is made in is traditionally regulated. It's the medical field. And the next analogy that we can make with the commercial speech doctrine is the court, again, stating in Central Hudson that information that is intentionally misleading, Your Honor, may I finish my sentence?
Yes.
Should not be held to the same standard as other speech. Thank you.
All right, thank you, counsel. We will hear from the respondent. Go ahead and proceed.
Mr. Chief Justice, Your Honors, and may it please the Court. This case today is about the ability of board-certified physicians to provide their patients with effective and honest medical advice. Due to the legislation articulated by the government of Florida, the Firearm Owners Privacy Act, or FOPA, the ability of doctors to communicate with their patients about firearms is entirely incapacitated, and public health throughout the state is suffering as a result. FOPA was enacted to quell the dissemination of factual information about gun ownership and safety following the hurt feelings of individuals from discussing firearm safety and responsibility with their physicians.
Well, counsel, why is there Article 3 standing? Because based on the discussion of the affidavits in Judge Cook's preliminary injunction ruling that your clients submitted, they take themselves outside the scope of the statute because they all indicate they want to discuss it for a legitimate medical reason.
Your Honor, in the lower court, there was standing established due to that the physicians were self-censoring themselves, which was a cognizable injury. And then in terms of your point to that multiple times in terms of what they're doing, they are not being affected by the statute. That is the issue, that they're having to self-censor themselves without being able to fully express their First Amendment rights. As these feelings are legislated, meanwhile, more than 33,000 people die of firearm-related deaths in the United States annually. Additionally, today alone, 19 children will either die or receive emergency treatment from a gunshot wound in the United States. There are these 6 incidents that brought on the enactment of FOPA from the Florida
Were
population.
any of those statistics in the record that the district court judge considered?
No, Your Honor, they're from the Center for Disease Control.
So how can we consider them if they're not in the record?
Your Honor, they were referenced, previous years were referenced, however, the most up-to-date ones are from the Center for Disease Control.
So what are we supposed to do, just go search the internet to find these facts?
No, absolutely not, Your Honor. There were references to the Center for Disease Control's statistics in prior cases from prior years, and then these are just the updated statistics for this year, for the most recent data. These incidents that have been reported, they are uncorroborated, they are few, and they are frankly dramatized in partisan interpretations to attempt to validate the necessity of FOPA, despite that it is a special interest-sponsored, blindly pro-gun bill.
So how much anecdotal evidence would be enough? Or is the court supposed to be the one to step in and say, well, the legislature, you can have 20 incidents if they're serious, but 6 or 7, that's not enough. Are we the ones who are supposed to look behind what the anecdotal evidence is and decide whether they got it right?
No, Your Honor. The legislature is able to look at constituent complaints and to validate those complaints with legislation. However, here, when looking at these specific instances that are better remedied and able to be remedied with Florida medical malpractice statutes and other federal protections such as HIPAA, then therefore when this legislation is coming in, then it is just superfluous and an unnecessary infringement on the First Amendment rights without remedying anything such as these specific instances that have come forward.
If we decide that this is professional conduct, do you concede that you will not prevail under rational basis test?
No, Your Honor. Under any standard of review for this law, it is very difficult to even say that the Firearm Owners Privacy Act is rationally related to a government interest due to that it is unclear of how this is exactly protecting Second Amendment rights, since no one is actually having their right to keep and to bear firearms infringed upon or have that protected by FOPA.
How about the right to privacy?
Your Honor, regarding the right to privacy of these medical records, again, to reference the federal statutes that are already in place, such as HIPAA, to protect the privacy of these medical records, there are already ample protections in place to keep that information private.
Doesn't the patient have a right not to be cross-examined by the physician about gun ownership? Isn't that a privacy concern?
Absolutely, Your Honor, regarding that they do have a right to not be cross-examined by their physician to the point that they feel uncomfortable. However, that is not what is going on here, and that is not what is being protected here. And rather, from individuals being cross-examined, physicians are not able to just speak with them at all and are fearful from even documenting information from when they do speak with them.
Well, that may be one way to view the statute, but this is a rational basis test. We're not in a position to second-guess the legislature's decision. There is an argument to be made that's rational and supports protecting privacy interests, Second Amendment rights of the patient.
Your Honor, so the privacy interests, again, are already protected, which again just makes this law overzealous in terms of that it is infringing upon the First Amendment rights without actually doing anything to protect the Second Amendment rights to keep these firearms.
Couldn't the legislature decide that the existing protections are insufficient, that this is a further protection that is warranted under the circumstances?
Your Honor, the legislature could decide that. However, again, going through these specific instances and what occurred here, there does not seem to be anything that's indicating that they need to legislate in that way, which then for them to be totally freezing the physician's First Amendment rights is unnecessary and makes this law invalid.
Is it totally freezing? I think there was an example by one of my colleagues earlier about videos that you could show in advance in the waiting room talking about gun safety. That wouldn't be prohibited by this law, would it?
Your Honor, it is very unclear what is prohibited and what is not prohibited by this law, such as that video. For example, many of these instances that brought on FOPA being enacted were merely individuals being asked about firearms to begin with, or being told that they should practice safe gun ownership and whatnot, and people became upset, people felt uncomfortable, people did not want to disclose that information. And then under these statutes, it is very unclear, and it's a subjective standard of if individuals feel harassed or unnecessarily harassed or discriminated against due to their firearm ownership.
Well, if we look at it in context, the harassment provision and the unnecessary harassment language, I mean, can't we all say we know if a doctor is harassing someone about weight loss or smoking or that sort of thing, that could be necessary because it's related to their medical condition. But looking at the circumstances, harassment about gun ownership could be unnecessary when it's not related to their medical condition. And so just a reasonable person could look at the language and distinguish between necessary harassment and unnecessary harassment.
Your Honor, regarding the unnecessary harassment and then the hypothetical that you posed of someone who it is not relevant necessarily to their specific medical care, the physicians filed an affidavit in the district court saying that they always like to ask because you never know when it is going to be relevant in the future. You never know when it is going to be relevant even in that very conversation, going through with that individual's specific circumstances and issues going on in their life. And again, this is not a standard that the physicians are aware of, regardless of that it may be reasonable for one person to think they know when they are being unnecessarily harassed. It's impossible for another to understand that specific standard from a subjective view of the other person.
Well, counsel, you indicated how many people were injured and killed by gunshots. And would you agree with me it's far more numerous than the number of people injured or killed by lawyers at oral argument? I'm just kidding. But here's my question for you. If the doctors wanted to find out about gun ownership in order to tell the patients how to treat, for example, an emergency gunshot wound, that wouldn't fall within the scope of the statute, would it?
Your Honor, just to make sure I understand this hypothetical, this is a primary care physician speaking with an adult patient who is telling that individual how to care for an accidental or a purposeful gunshot wound?
Correct, because the statute talks about safety of the patient or the safety of others.
Yes, Your Honor. Again, it's very vague given this statute of if an individual then could raise a FOPA action, even with such good practical advice such as that, even regarding anything regarding fire ownership.
Well, what's vague about the statute with regard to that hypothetical?
With regard to that hypothetical, another hypothetical, Your
Well,
Honor.
how about the hypothetical I asked you?
Oh, yes,
What's
absolutely.
vague about it?
What's vague specifically about that hypothetical?
About the statute applied to the hypothetical?
Yes, Your Honor, is that that individual who's being spoken to, if they felt like it was unnecessary harassment for them to be spoken to by the physician about that specific subject matter, they're absolutely, within this statute, able to raise a violation with the Florida Board of Medicine, which could lead to that physician's revocation of their license, which is a very extreme repercussion for, again, giving good practical advice about a firearm wound.
But any patient can file a complaint with the board at any time for any reason.
Absolutely, Your Honor. However, this is giving reasons for people to file violations when they are merely uncomfortable or when they merely do not want to communicate about this one specific content-based type of speech.
Isn't there a good faith safe harbor for the physician if they're doing this in good faith?
Your Honor, one of the standards of vagueness that has been articulated by this court is that a standard is void for vagueness if it subjects itself to subjective enforcement, as does FOPA here. So, for example, although in some jurisdictions, in some courts perhaps, a physician may be able to push individuals onto their firearm ownership to get information out of them and to give them good advice, in other jurisdictions they may very well be subject to discipline for that, again, going to the vagueness of this statute.
But doesn't the statute itself say that there's an exception if you're doing it in good faith as a physician, if you've got a good faith belief that it's necessary?
Yes, Your Honor. However, many physicians, again, state that they need to inquire about this in order to even determine if they do have a good faith determination. And they're unable to make that determination without making records and asking questions and speaking with their patients then. It's an impossible task to develop relevance if you're unable to ask questions and determine the relevance.
Continuing the vagueness discussion, doesn't the statute safeguard against arbitrary interpretation here by leaving it to the discretion of the doctor as to what is relevant?
Yes, Your Honor, in that a physician should be able to determine the relevance on a case-by-case basis with their patients, what is relevant. However, then what the statute does not protect against from an outsider coming in and looking at that interaction and determining that they do not determine it to be relevant. And additionally, then the physician is unable to defend himself or herself because they were unable to make records of their conversations with that patient specifically.
So I'm going to go back to a more overarching question. My colleague had asked you earlier about what happens if we apply a rational basis test, but what level of scrutiny are you arguing we should apply here?
Strict scrutiny, Your Honor.
All right, and why should we really differ from what was applied in Planned Parenthood versus Casey, which would be just heightened scrutiny?
Your Honor, as the state of Florida referenced in Planned Parenthood versus Casey, that was the government imploring or requiring physicians to give truthful information to their patients about abortion procedures. Here, what FOPA is doing is prohibiting physicians from giving truthful and factual, useful information to their patients. And then beyond that, as you said, there is a chance for modified scrutiny under Casey. However, that is not the circumstance here due to that is the withholding of truthful information, which is going to go against patient autonomy and the ability of individuals to make their choices for themselves based on the information to the best of their knowledge.
Why do you think the 3 panel opinions in this case had such a difficult time figuring out what the appropriate standard of review is?
Your Honor, I believe that honestly why it is difficult to establish the standard of review here is to a point that I made earlier regarding that it is very hard to establish what is the compelling government interest here, whether it is the Second Amendment protection that is not very clear, whether it is privacy that is already handled and does not really need additional protections and can be established. And I feel like that is the difficulty in establishing the effective standard of review for this specific type of professional speech. To go back to the vagueness analysis, by definition, FOPA is void for vagueness within the meaning of the First Amendment because it does not give a person of ordinary intelligence a reasonable opportunity to know what the law prohibits, and it is so standardless that it authorizes or encourages seriously discriminatory conduct. Here, what we have with the physicians is forcing them to discriminate between their patients in order to define relevance and in order to make determinations of who needs to be spoken to about firearm ownership and who does not. This statute is on its face, forcing these physicians to discriminate between their patients and to profile them, which makes it void under the First Amendment due to vagueness. Additionally, under the NAACP versus Button, a statute is deemed unconstitutional for vagueness if the statute lends itself to selective enforcement against unpopular causes. As we touched on a bit earlier, but to cover again, depending on what region, what jurisdiction of Florida a physician may find him or herself in, they may be subject to prosecution in that specific jurisdiction due to the popularity of Second Amendment rights or gun ownership and what people are trying to prove in that particular jurisdiction.
Where's the evidence of that in the record?
Your Honor, there's no evidence of that in the record. Rather, this is just merely the way that things will work out in terms of the discretionary enforcement of the subjective ability of people to raise these violations based on their feelings, their personal feelings on firearms. Regarding the enforcement under Winters versus New York, a statute was found to be void on its face due to vagueness if it permitted the punishment of incidents that are within the guarantee of free speech. Here, physicians would receive punishment for merely communicating, for merely speaking with their patients in the practice of their regular medical profession. Although perfect clarity and precise guidance are not required of legislation, as the government of Florida stated, but content-based regulations of speech require a more stringent vagueness examination and raise special First Amendment concerns because of such laws' obvious chilling effects on free speech.
What's the origin of the content-based presumptive invalidity of a statute? What's the origin of that legal concept in First Amendment law?
Your Honor, most recently came up in Reed versus Town of
Yeah,
Gilbert.
that wouldn't be the origin, though. That'd be the last case. I want to know what the origin of this principle is.
Absolutely, Your Honor. Laws that restrict speech based on its communicative content are presumptively unconstitutional under Ashcroft versus ACLU, and content-based restrictions are limitations or prohibitions on speech because of the message it conveys, including its subject matter or viewpoint, and that was Snyder versus Phelps. To go back to the vagueness of the provisions here regarding the inquiry provision, where the act requires that physicians must refrain from making written inquiry or asking questions concerning the ownership of firearms. Florida's government has released multiple statements saying that this is not an advisory that this is an advisory and not a prohibition, meanwhile also releasing other letters and other advisories saying that they intend to prosecute physicians about this specific statute. Therefore, physicians are entirely unable to know what is going on here and when they will be subject to discipline from the Florida courts. This is not a hypothetical of speech being silenced, but rather the physicians have already needed to self-censor their speech. Regarding the anti-harassment provision, to go over that again, the physicians of Florida have no way of determining where their free trade of ideas ceases from attempting to persuade individual patients into an American Medical Association prescribed course of action regarding firearm ownership.
Well, you're saying that doctors can't tell the difference between harassing someone and having a discussion with them about a subject?
Your Honor, just to emphasize the subjective nature of who is deciding, it is the patient who is deciding whether he or she is being unnecessarily harassed.
Don't we deal with that kind of issue all of the time? And for example, workplace harassment. You know, is a lot of times you'll have somebody who is the harasser who they would say they have no idea that their conduct is harassing, and you look at the subjective view of the person being harassed. And why can't we take those standards from other areas of the law and apply them equally here? Say, if you can know what harassment is in the workplace context, you can know what harassment is in this context.
Your Honor, that is a good analogy for what is going on here, of that there is something that is occurring, that people are unhappy subjectively with their experience with their physicians, they feel harassed. However, many workplaces now have policies in place that specifically dictate what you should and should not do when you're interacting with your coworkers.
Well, that's great. And then medical practices can have policies in place as well, just like that. It's not the government isn't issuing those policies, it's the workplace that's issuing them. The AMA could issue policies explaining what unnecessary harassment is. We could go by the standard of a reasonable person. Would a reasonable person view this as harassment? We've applied that before.
They absolutely could, Your Honor, but however, then regarding this specific statute and what is going on right now, the AMA could make these requirements or these stipulations to guide physicians. However, when looking at the vagueness currently right now of this law on Florida physicians who are wanting and who are unable to communicate with their patients effectively, this is a silencing on speech, and therefore it is a First Amendment violation with this specific statute, regardless of any other policies that could come about in the future further clarifying this statute. To quote this court in Sorrell versus IMS Health Incorporated, many individuals must endorse speech that they simply do not like, as is the cost of freedom, because especially in fields of medicine and public health, information can save lives. Because of the Firearm Owners Privacy Act, a physician is left without notice of what truthful information may be appropriate to communicate with a patient regarding the public health repercussions of firearm ownership, withholding life-saving information. Your Honors, to summarize, FOPA has already caused unquantifiable damage to the public health of the state of Florida by requiring physicians to sacrifice the... Your Honors, may I conclude?
Yes.
The state of Florida is prohibiting interactions between physicians and patients in the examination room in favor of what is now an epidemic of interactions between physicians and gunshot victims in the emergency room. Thank you.
Thank you, counsel. All right, we will take the matter under submission.
No, she has 4 minutes.
Oh, I'm sorry. That's right.
Thank you, Your Honor. I'd like to address a few points that respondent brought up during her direct. First is the respondent contests that this act would quell the dissemination of gun safety advice. However, this act is much narrower than that implies. First, it is narrowly tailored to only irrelevant, unnecessary, and discriminatory speech. And next, just to touch on the court's hypothetical of the video playing in the waiting room, that would be permissible because it does not, because the act merely seeks to regulate the patient's interactions with the doctors on a one-on-one basis. The court in Justice Lowe's concurrence or Justice White's concurrence in Lowe, he stated that the definition of professional speech would require two prongs. The first would be that speech is made within the furtherance of the professional's practice. And second, it's between the patient and the doctor, or the professional and the client. And here, that examination room or that waiting room hypothetical would not fall under professional speech.
What standard of review did Judge Jordan articulate in the majority in-bank decision in this case?
Your Honor, the 11th Circuit en banc did not state that it would apply a particular level of scrutiny, but rather that this act did not pass heightened scrutiny.
So couldn't we do the same thing?
Yes, Your Honor. However, this court should apply heightened scrutiny and pass it. But even if it does apply strict scrutiny, again, it passes because of the compelling governmental interests at stake and the fact that this is a narrowly tailored act. Next, the respondent contends or suggests that patients would be able to affect the doctor's ability to practice law because potential sanctions against the doctor do include a revocation of the license. However, these cases would be heard by the Florida State Medical Board, which has the expertise to hear these types of cases. And next, moving forward to the respondent's vagueness argument, the standard under NAACP, this court specified that for First Amendment cases, the standard is whether or not it's susceptible to sweeping and improper application. In this case, it is not. Furthermore,
Counsel, under Florida law, is there judicial review of the State Medical Board's decision?
Your Honor, I regret to say I do not know. Further, under Hill v. Colorado, in a facial challenge, the challenger's burden is to show that in a vast majority of applications, this act would not be constitutional. And that is simply not true. In a vast majority of these cases, a reasonable person would have the ability to understand what relevant speech is, what unnecessary is, and what discriminatory is. And finally, just to reiterate, this act, the respondent brought up Sorrell and emphasized their quote on life-saving information. But Sorrell, again, is the seminal case applying heightened scrutiny to commercial and content-based restrictions. Therefore, the court should follow that decision and apply heightened scrutiny. Thank you.
Thank you, counsel. Now the case is under submission, and we will adjourn briefly for a few minutes. All right, please be seated. Well, before we announce the winner, if you could both stand up, because otherwise I'm not tall enough to see over this ramp. We just had a few comments. Outstanding job by both of you, very poised and professional. Judge Staton.
Yes, normally I take notes during an oral argument so I can give constructive feedback and give specifics, and maybe if I have a little bit more time, I will be able to think of those because I couldn't take notes. I was really engaged with what you were saying. You moved quickly through your points. You did and when I'm saying this, I'm saying it to each of you. You did a wonderful job of responding to rapid fire questioning and then moving back to your own points without really missing a beat. It was really masterful, and I have to say that while I sit on the Ninth Circuit on occasion, I have oral argument in my court frequently, weekly, and I pepper the attorneys with questions, and if I could have them respond the way you responded, I would be a happy camper at every oral argument because you You really knew the material very well, so well done to both of you.
Okay, Judge Bennett.
Thank you. Absolutely spectacular. I mean, I tried to ask tough questions, but you did a wonderful job. And I've judged many dozens of moot court competitions. I also sit on the Ninth Circuit. I've sat in over 100 oral arguments, and I would put you two in the top 5%. And I've been a district court judge for 24 years, have lots of oral argument. You'd be in the top probably 1% of the lawyers that have argued in front of me. Just spectacular knowledge, and you were so responsive to the questions. Just absolutely outstanding. I will say of the 3 other moot court competitions I've judged in the last 6 months, you're far and away the best too. Far and away.
Yeah, I agree with the comments. Both of you were outstanding. Oral argument's an art, and it's surprising how poorly it's done. I see that all the time. There's a tendency to, especially with the question, we just hammered you with question after question very quickly and very rapidly, and you both kept your poise. I've seen seasoned lawyers just turn into, like this human dartboard, and as we fire one question after another, and neither of you succumbed to that. You both got back to your prepared arguments, segued back into your arguments very nicely. I was just very impressed with how concise and tight your answers were and responsive. Terrific job by both of you. And it was very, very close. And so in announcing the decision, I want you to know that it was not a unanimous decision. So that's how close it was. But the petitioner, Ms. Rice, came out just barely ahead. So congratulations to you. Congratulations to both of you.
Any lawyer that can answer a question about a footnote and nail it, I am super impressed.
All right, and with that, if you wanted to talk to us individually, we're available right afterward and at the reception. Thank you very much. Court is in recess.